Hello, members. Welcome back to Agora Legis, the platform of legal minds, where we discuss legal principles and make them easy to understand. We literally make the law easy for you. And in today's topic, we shall look at the law-making process in Uganda, of course. And we shall look at what the law-making process is, who does the law, the legal framework, where is it provided for, that this is the way that the law has to be made. And we shall also look at the principles governing the bill drafting, and also we shall look at the steps followed, the 5 major steps followed in the law making process. And so without further indulgence, I'm Counsel Ben, and let's jump right in. So to start with, the law making process is simply the process that is gone through while making a law, while legislating. So it's also referred to as the legislative process, literally saying that they are making the law. And also, who makes the law? It's the parliament, the legislative body of the country, mandated under Article 79 to make the law, and it is also established under Article 77. So the parliament is the legislative body of the country, mandated under the 1995 Constitution of Uganda to make the law. That said, we shall also look at what or where is it provided for, the legal framework governing the law-making process. We shall first look at the first and foremost, the 1995 Constitution of the Republic of Uganda. We shall look at the rules of procedure of Parliament, and that is statutory instrument. It has no cap. It's just a statutory instrument. So those are the 2 major statutes that provide for the law-making process. But for further knowledge, you can go also and look at the judgment in the case of Malema Birisi versus Attorney General. It's a constitutional action, of course. And as so we have seen what the law-making process is, the who makes the law, and the legal framework of the law-making process. And so we shall also go and see the principles of a bill drafting, just quickly going through them. When a bill is being drafted, it has to be in a clear and simple language to avoid ambiguity and misunderstanding. It has to be gender neutral. It should not be referring to only men or only women unless that is what they're meant. For example, in the penal code, a woman cannot rape, but a man can rape. So that is specific, unless it is specifically said that that is what it's meant in the law. However, it should be gender neutral. It should take in account the people to whom, or the end user of the law, the people that are directly affected by the implementation of that law, and so many other principles that govern the drafting of a bill. And so I would like now to jump right in and to see the steps of the legislative process. So first and foremost, I would like just to notify that I summarized them in 5 major steps while making a law. 5 major steps. And it starts with the first step, that is the pre-legislative consultation in form of a green and a white paper. The green paper is to show the area in which the minister or the ministry or the private member wishes to legislate, And then the white paper is to detail proposals of the law that are wished to be legislated. But before we continue, I would like to not to say this, that there are only two, okay, so far two types of bill: a government bill and a private member bill. The only difference is that the government bill is initiated by a ministry or a department of the government, whereas the private member bill is initiated by a member of the parliament. And so I was talking about the pre-legislative consultation in form of a white and a green paper. Green paper showing the area in which they wish to legislate, and white paper showing the exact problems that they wish to legislate on and proposals of the laws wished to be legislated. And as so, there will be the submission of a report to the cabinet by the minister concerned in form of a memorandum to show that that report to be given to the minister. The following step, still under the pre-legislative consultation, is that the cabinet considers the proposals in the memorandum, and the cabinet authorizes the responsible minister to issue drafting instruction to the first parliamentary council, and then the minister concerned will request the first parliamentary council to draft the legislation. So here we already have a bill in the pre-legislative consultation, and then the drafting of the bill. First, there is the green and white paper submitted in a memorandum, and then the cabinet will approve that proposal of that law and authorizes the minister to issue the drafting instructions to the first parliamentary council. So the first parliamentary council will draft and then gives back to the minister. Then here is where we come to our second step, that is the submission of the bill to the cabinet. So here the bill has been drafted. Then now the bill is submitted now to the cabinet, because the cabinet first approved the proposal of the ministry. And then when the drafting is done, they come now to submit it to the cabinet. So what is to be submitted to the cabinet? Of course, the bill itself, the legislation, accompanied by the certificate of compliance issued by the office of the first parliamentary council, and then also the certificate of financial implication issued by the Ministry of Finance. And as so, we have seen that the two first steps, the pre-legislative consultation and submission to the cabinet. Third step in the lawmaking process is approval by the cabinet. So here are things that are to be done before a bill is tabled on the floor of the parliament. So the first thing to be done is submission of a memorandum. Submission of an explanatory memorandum setting out the principles of the bill that is being proposed. The second thing is that the first parliamentary council will authorize the government printer, that is the Uganda Printing and Publishing Corporation, UPPC, to print the legislation. Then there is what we call the local purchase order. The local purchase order is the order that the minister concerned brings to the UPPC, the government printer, in order for them to give them a budget, an estimated budget on what is it going to cost while printing, because they don't only print one exemplary. They later on we shall notify that the ministry has to submit 450 copies of the bill to the clerk of the parliament. So there is a cost, of course, to that, and that is also to be done. And of course, now after that submission of those 450 copies to the clerk of the parliament, and then the certificate of financial implication of that bill issued by the Ministry of Finance. And that is the third step in the lawmaking process. So later on we shall now see the fourth step in the lawmaking process, that is introduction of the bill into the parliament. Here we only have three things. There are readings, of course: first reading, second reading, and third reading. In the first reading, we shall see that the clerk of the parliament will read aloud the short title of the bill, and it will be considered to have been read for the first time. At this stage, the committee invites the ministry concerned and all the stakeholders. Stakeholders are those people who are directly implicated in the initiation of the bill. Those are the stakeholders. The committee will invite the ministry concerned and the stakeholders to give their opinion on that bill, and then the bill will be referred to a specialized committee to make further research on the laws that are being proposed and their implication. And then we have the second reading. But before going to the second reading, this committee that is to which the committee to which the bill is referred to for it to go and make research is to bring a feedback, or is to bring a report within the 45 days after submission. Then in the second reading, the parliament in the parliament, the law will be read, or the bill will be read section per section and debated to see whether this law is accepted. This subsection, no, it's not accepted. This is subject to amendment. This is subject to review. So that is what happens in the second reading. It's the longest, actually. And then comes the third reading, where the bill won't be debated anymore. It's just it's just a matter of formality to pass it upon a motion. And then that is the fourth. But before going to the last, I would just like to hint something here about withdrawal of a bill, because someone who initiates it can also withdraw it. So let's say for a private member bill, a member of a parliament can withdraw the bill at any time before it is passed or before it is assented to. So that is it. It's actually as simple as that. And then lastly, the fifth and last step in the lawmaking process of the parliament is assent and publication of the law. So the law, after being read for the first time, the second time, and the third time in the introduction of the bill in the parliament, of course, the law is approved by the parliament. But now remember, in the constitution, the law, any law that is passed by the parliament has to be, or that is approved by the parliament, has to be brought before the president of the country for assent. And how does the president assent to a bill? He has to sign on each of the 10 copies presented to him, and that is how a bill is assented. But he has to do that within 30 days, and where there is something that is subject to revision, that the president says this one should be reviewed, this one is not good, it should also be subject to revision, it goes back to the parliament again. But now, after 3 times, for the third time, the parliament is mandated under the constitution to pass the law without assent of the president. So this is how it happens. The president assents to the law, of course, and it passes directly, and it's published in the Gazette. And then, but if the president does not assent to the law, the parliament can pass it without assent of the president. And that is it, actually, all about the 5 steps of the lawmaking process. And lastly, the law will be published in the Gazette and will be put in application. I would just like to emphasize on something that I wanted to explain them straight without referring to so many references, because I first wanted us to appreciate what is to be done, literally what is to be done. Then, for more reference, you can go on and look in the Constitution from Article 70, from Article 77 to Article 92, something like that. You will find there those things that I've been talking about, found in the Constitution, but also in the Rules of Procedure of Parliament, statutory instrument. And lastly, you can go on and read some cases about the lawmaking process that were challenging the constitutionality of some laws. For example, the famous case of Malema Berry-Zivala, Attorney General. Thank you so much for watching. Share, like, subscribe, and I really emphasize subscribe. Don't watch for free, of course. Everything is free, but you can just support the channel by subscribing so that you don't miss anything. The contacts for more information are in the description down there. Thank you for watching, and see you next time.